in specific relief act, if you see, if damages are sufficient, they will not enforce the contract specifically. If damages are not sufficient, the contract will be enforced. And if it's a contract for immovable property, it will be enforced. So the question in that was whether development rights is an immovable property. What the Bombay, you have understood this. So what the Bombay High Court said was this. Under the Transfer of Property Act, immovable property also includes benefits that arise out of land. So they said a development right is a benefit which arises out of land and therefore becomes immovable property, and therefore it can be specifically enforced. Therefore, if in your case it is an immovable property, then it's a transfer of title to immovable property, it's not a service. Now coming back to my subject. This is one view. This is one view. I am not saying this is the view. This is one view. So if you transfer development rights, it's a benefit that arises out of land, and therefore there is no service tax because it's transfer of title in immovable property. One view.
So the judgment was Cheda construction.
I would not know this. I can't pronounce or spell those. It is very difficult for me. If I go beyond Andhra, I am lost.
Mutual, sir. It is mutual.
Huh?
It is mutual, sir.
Yes, everything is mutual. So if you look at that decision, you use it.
Yeah.
Use it.
You use it, sir.
Please use it. Now we will come to healthcare. No, did I finish the food services?
No.
I'm sorry, see, I get carried away. Cut me short if I get carried away somewhere. How much time? I have some time? I have a lot of time, don't worry. Now, food facilities, if you see, in my view, this is purely my view. In my view, food facilities that are given, outdoor catering or whatever that is given, is a business necessity. It is used for providing output service. My view is this: if I don't give him lunch, he will not work. Business retaining employees. Retention of employees, one of the easy people work 12 to 14 hours. Can you expect them to go, if they go out for food and come, it's going to be 1.5 hours. Give them the food in the canteen, it will be a matter of half an hour. So what are you doing? You are just saving time for yourself. In my view, it is a service used for providing output service. You may say, how is it linked to the, where is the nexus? I know that most of the tribunals in this country will say there is no nexus between providing food and the service being rendered, or whatever is the output which is being rendered. Let me tell you, but can you work without food? Here also I feel the test should be each business, whether it is required to run it the way they want or not. That should be the test. It should not be the test viewed from the judge's point of view, whether it is necessary or not necessary, keeping in mind his background and his family, orientation. It should be what that man wants and what that man's orientation is. So, in my, I should also tell you practically, what is the chances of you winning in litigation is less than 10%. Because the way that has been worded, the exclusion clause has been worded, which shows outdoor catering, very clearly says it is primarily meant for consumption of employees. So your chance of winning in this food facilities is very less. But I would still say contest it because it will add to the growth of case laws.
Sir?
Yes, sir.
Other than those actors which are excluded, everything is included, we can take that way?
Please do it. See, I follow a simple principle in semi-credit rules. When in doubt, take semi-credit. Now coming to the sixth question.
Small doubt. Say clause C of the exclusion. When such services are primarily used for personal consumption,
Yeah.
then applies to only the last part of the clause C or the complete all the items listed in clause C.
All the items.
All the items.
Yeah. I am of the view that that is listed, that is meant for all, it qualifies all the items, including outdoor catering and everything. Yes, 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 beauty treatment. Let me tell you, see, you take your TV anchor people, for example. Without the beauty treatment, is it possible for you to see them? I'm sorry. Is it possible? It is an absolute necessity. Whether male or female, you know that with makeup, some people look good and without, you can't recognize. It is an absolute necessity. We can't look at our actors and actresses without the makeup. We have got used to that. It's a necessity. It's a business necessity for them, a professional hazard for them, let me say.
But still, will it amount to personal use?
In my view, it is not personal use because none of them are putting makeup because they want to look good. They have to look good so that the TV ratings will go up.
Business requirement.
It is a business requirement for the channel. It's a business requirement for the channel. So, in my view, the test for any of this will be whether the business needs it or whether the employee needs it. If it is the business which needs it, credit should be allowed. You may ask me then, what is it that the employee needs? Everything is business means, well, what is the use of that exclusion clause? That will be the next question. If you say that it's all a business exigency, then why need that exclusion clause at all? It's a good question to ask, but I am not going to answer it because it is for the government to answer it. If you have included an exclusion clause, you tell me why you have done it. I am not going to answer it. If you see the case of Majestic Mobiles, which I had an opportunity to argue, the issue was this. This is why the amendment came about in section 80 of the Finance Act. Notwithstanding anything contained in section 76, 77 or 78, that is how it starts. No penalty shall be levied if there is reasonable cause. We stop there. So this matter, when it came up to the tribunal, I said, even if there is collusion, even if there is suppression, if there is reasonable cause, no penalty shall be levied. Because there is a non-obstante clause which refers to section 78. Departmental officer said, sir, your lordship, if there is a collusion and there is a evasion, how can there be reasonable cause? So I told the judge only this. Service tax was introduced in 94 when compliance is very low. Now we are in 2000, 2001, 7 years, 8 years. Compliance is very low. So even if there is collusion, we will let you off if you pay the tax, provided we will bear the penalty under 80 and say that there is reasonable cause. That is the reason for which section 80 was introduced. So that people will complain tax. If you tell them, if you go to a consultant and he tells you you have to pay tax, you have to pay mandatory penalty, nobody will complain with the tax. Nobody will complain with the tax. If you tell him you come pay 100% penalty. To make him complain with the tax, you introduced a notwithstanding 78, I will still pay. And Majestic Mobiles, they said yes. This was upheld by the Karnataka. Then they made the change saying not, except, I think, proviso to section 78, you will see that. That was introduced to get over Majestic Mobiles. Now we'll come to question 6 is a fairly easy question. I think all of you have got it completely right. In the sense, I would not say right, your understanding is in sync with my understanding. There's nothing like right or wrong there. It is in sync with my understanding, that's all. Essentially, see, I remembered, I had one matter where false ceiling was being put up for the purpose of air conditioning. in a 100% EOU. The issue was whether you can call it capital goods under the notification 52/2003 and other notifications in customs. So I argued on the question of technical necessity. A 100% EOU requires a false sealing with an air conditioning as a technical necessity. If there is something without which, you take the celebrated case of JK Industries case. If you cannot carry out a process in the manner in which it should be carried out, this comes in 91 EAD. JK, but actually it's a very old case. In 1963 or 61 you will find this. Very old case. Say in the sales tax. If something is necessary for your production or manufacture, then that will constitute an input. That is JK Industries case. This is a ratio. So if something is a technical necessity, it is essential. Why I included this question, however, was just to see whether you are looking at it as a technical necessity. Is it a condition for this? I do not know if you people discuss this. Is the present set of standard credit rules based on technical necessity as far as capital goods are concerned? That was the question. Even if it is not a necessity, but it is used in my factory or used in the office of the service provider, can I take standard credit? Yes. I don't need to justify technical necessity anymore. Capital goods used for providing output service, over. But when it comes to the usage, used, then the technical necessity comes. I want you to take this distinction. When I say used, that means it should be used for providing. Then the technical necessity comes. So therefore, you are all absolutely right in saying that this air conditioning equipment for controlled temperature conditions is a necessity. Not only is a necessity, but if it is found in my premises, automatically I am entitled to capital goods credit. That is my view. Coming to question 7, that question 7 was deliberately designed to give a surplusage as well as to show you the difficulties of the LTU vis-a-vis ISVC. Because many assessees have created certain, they've gone wrong. Let us look at these two schemes. LTU is a self-contained scheme. If you go under LTU for all your services and manufacture, this particular client would not have fallen into this problem at all. If you go for your LTU for all your units, the question of going for IST does not arise. Why? Why? Because in the LTU, you have a specific provision in standard credit rules which allows you to issue transfer challans between the units. There is no need for you to go to IST at all. What has happened here is a typical live example. The first two, you just take these 4. In this, the first 2, that is manufacturing units at Ahmedabad, Bangalore and Belgaum and Bangalore, marketing and service providing units, Mumbai and Delhi, these were all registered as LTUs. Under the LTU scheme, I declare all of these people. Typically, I would have opened a marketing office later on in Noida, Calcutta, Chennai, wherever it is. important to include these units as LTU? I have simply forgotten. I have registered my Bangalore as an ISD. This ISD would have continued, I would have got the ISD registration done first and then would have gone for LTU. Now, if you look at registration of special persons category rules 2005, you look at it carefully. I believe that this may not, I don't know if this was discussed. This may not have been, did you discuss this? In that it says, the provisions of rules 4 bracket 2 to 4 bracket 8 of the service tax rules will apply. 4 bracket 2 has to deal with centralized registration. So even if I have made a mistake, the provisions of centralized registration will apply even to ISDs. If I have registered centrally at any unit, I can take credit for any of the units, wherever it is. Dehards the LTU. Under the ISD scheme, if I am centrally registered, what is the question here? At Bangalore, I am paying all the taxes under the ISD. I want to distribute the credit. Even though I am registered as an LTU, I may still want to distribute the credit to the factory and then payment comes. Payment is made. I receive an invoice which is in the name of Noida. That is not registered as an ISD. Right? But I have centralized registration provisions which will include even the ISD. That is what is the answer here. The centralized registration that I take is valid not only for my service provision, it is valid even for my ISD. Because the registration of special persons category rules says the provisions of 4 bracket 2 will be applicable. Have you understood this? And therefore, I can take credit on any of the documents that come anywhere. There is no need for me to get into any of this, get into arguments saying after all it's a technical flaw. There is no flaw. There is no lapse. The only lapse that has been created by this man is he should have included everything in LTU and closed this chapter. Then he can issue transfer challans without this ISD necessity at all. 8th question. This is a very interesting question, the 8th. Your answers are also very good. I was very happy with your answers. Now, the question is whether Rule 6 bracket 3b will operate and he can take 50% of the credit relating to the inputs also, or at the threshold itself it is knocked out. At the threshold itself it is knocked out. It is not at all an input. This is the question. I think the identification of this question was done beautifully by all the participants. I was very happy with that. Solution is not happy. Any solution in Senate credit which says that you are not entitled to credit, I am not going to take it. You may have, I have my personal convictions, like everybody has his personal convictions. I have a conviction that any credit should be taken. Huh? Every credit should be taken and leave out. I will tell you why. See, the arguments are very good. When you go to the definition of output service, it says any service which is included in section 66D is not an output service, correct? So perfectly alright. So input, when you come to rule 3, the input should be used for the purpose of providing the output service. Now your argument is since an output service does not include trading of coins, which is included in the negative list, and therefore there is no question of taking credit because not at all an input. What is exempt service? Why have you not looked at exempt service? Exempt service includes a service on which no tax is leviable under section 6060. Correct? Those which are included in the negative list, no tax is leviable under 6060. Well, why can't it be called exempt service? That is the first question. It may not be an output service, but it could be an exempt service. But then you will say, Rule 3, it says that it should be used for providing output service. It does not say exempt service. Correct? Yes, sir, please. Please tell me, because it's a very important question. Please tell me. What is your observation?
One of the observations would be that output service is already included in the definition of an exempt service.
No. Exempt service has its own definition. Output service has its own definition. They will say Rule 3 specifically says output service. It does not say exempt service. How do you answer that? How do you answer? Come to Rule 6. Somebody said Rule 6, after all, is only a mechanism. This was the view then. Rule 6 is an obligation. That is how I read it. Please see the heading. Obligation. Is it right, sir? Rule 6 is an obligation. Now, you please look at explanation 1 to Rule 6.3d. What is value? Explanation 1 to Rule 6.3d. What is value? Correct? Value for the purpose includes trading. What is this? Have you found it? In case of trading, they take the margin, that's the margin, and also they say it could be 10%, whichever is higher. And then there is one clause in trading in securities with 1% and other things. My question to you is that if this SENMAT credit rules never envisaged credit to be taken, then why do you include this? If it has to be knocked out at the threshold, why do you require this in 6?
This is for the common input services.
No, I disagree with you. Rule 6 does not say common input services. That is it.
It doesn't say by implication.
No implications, sir. That was earlier. No implications.
So even about the service, so I beg to differ from one point.
Oh yes, please, sir. We are here to beg. We keep on begging to differ only.
Sir, because you are taking that trading is a service, but I go to the 65B44 itself, we say the transfer of the title in the movable property.
Yes.
Is excluded from the definition of service.
Then I am not at all saying no. You see how the negative list is worded. The negative list shall comprise of the following services. 60/60. So that means the implication trading is a service. As per the negative list, as per the Finance Act. When I come to SENMAT credit rules, the definition of service is not incorporated in SENMAT credit rules. Even if there is no transfer of title, or even if there is transfer of title in immovable property, it is not at all a service there. Here, in Rule 6, they include it as a service for the purpose of reversal, for the purpose of an obligation. It is a self-contained code, Raghuvar India's case, Supreme Court. Moderate. Therefore, it need not be a service. You are right in saying that transfer of title goods, it's not a service at all. 65B 44. Absolutely right. But they have included it as a service in negative list. They have also included it as a service in exempted services. They have also said that if it is used in exempted services, reversal should be done. If that be the case, they have included trading as a good. There is a sanitary principle in law that no words of the legislature is wasted, though the time of the legislature is wasted. If that is the case, you cannot say trading is a surplusage. If you cannot say it's a surplusage, and therefore it is included in this, otherwise how will you calculate that formula? You have to include trading. So in my opinion, you should use what one of your mentors said, and you brushed it aside. One of your mentors, I don't know if he is here, said that the business of banking includes trading in gold coins. Use that to say, I am a provider of output service. May not be this, but I am providing output service. I am a provider of output service. And therefore, in my view, operate the 6 bracket 3B, rule 6 bracket 3B, take 50% even on your inputs and lend your name to a famous case. You are right, you are, it is a highly arguable. This is the reason why I gave this example, because this is going to be a hotly contested topic between the department and the assessee on the interpretation of Rule 3, output service, exempt service, Rule 6, and 65 for 44. It is going to be a hotly contested. 50-50, not 10-9, 50-50. This has a good chance of you getting some relief over here, I feel. From what arguments I have led on Rule 6 in the past, I believe you have a very, very good arguable case.
So only one reservation here.
Yes, sir.
This trading, whatever you are saying the value, that comes by way of an explanation, sir. It is never in the main provisions or main section, sir. That is only an explanation. That if you treat the trading as a service, you take this value. It is only for valuing the trading.
There is a debate from the Supreme Court in 4380. Ahali Pharmaceuticals case.
What is the big case?
Ahali Pharmaceuticals case. Explanation is part of the section. Explanation is part of the section. If it is a part of the section, you have to give effect to it. If you have to give effect to it, if I am having a trading income, that means the semi credit rules have envisaged that trading is a possibility. Is a possibility. And they have included 6 bracket 1 to say what is exclusively used in exempt should be taken out. They have also